He said it's not reasonable to believe these findings are in any way related to the injury in question. When addressing plaintiff's injections, he states that injection is not related in relation to the date of injury. Additionally, when talking about plaintiff's CT, which I talked about previously in the motion to strike, that it was an MRI and not a CT, and Dr. Sklar misrepresented what imaging. He said since the CT scan was not necessary, that billing should be considered unrelated to the date in question. So I wanted to focus on those points so this wasn't drawn out. Obviously, as we all know, causation is not anything having to do or germane to 18001 controverting affidavits.
Your Honor, I believe you're
response.
Muted. Oh, sure. So to respond to that, I don't think the initial affidavit or the counter affidavit are any evidence of causation. I don't think, because causation is discussed in brief, that that's a reason to strike the counter, especially if the initial affidavits prove up records that also discuss causation. And I also, in my response, I did highlight the recent case out of the Texas Supreme Court in Ray Allstate, which gives us some guidance about striking counters and the reasonable notice requirement that the Supreme Court sort of laid out as fair notice, not a high bar, just to give the other side idea of why you're controverting the initial treatment. And I believe Dr. Sklar did meet that. He said there was no evidence of radiculopathy. He said that the findings were degenerative. Plaintiff's counsel takes some issue with Dr. Sklar's summary of the treatment. I think that's more properly addressed on cross-examination. And I think that these counter affidavits need to stand. So we're asking the court deny their motion to strike.
Your Honor, may I respond briefly? With respect to the...
You may.
Thank you, Your Honor. With respect to the response that was filed yesterday, the response focuses only on reasonable notice after the recent INRI state. There is nothing has changed so far from INRI Allstate, and nothing in the response talked about causation. We know that causation is not in 18001 affidavits. And with respect to some of the other things about reasonable notice, it's hard. There's multiple times Dr. Sklar has.
Can I ask a question though? I mean, if
yes,
we're only going to, I don't have any problem striking it as the causation. I don't think anybody else typically addresses that, and that's not appropriate. But if we don't, if that's all we strike, you would still have to call a doctor at trial, right?
For the, well, if the 1801 affidavit,
You mean to strike the whole thing because of the conversation?
If the contrary affidavit was completely struck, then if this case went to trial, I would not necessarily have to bring any doctor.
Okay. Response to that?
Well, I think you can't, or we shouldn't completely strike the counter just because it references causation. It'd be more appropriate, since that sounds like the big beef here, to just strike out the portions that talk about causation and let the counter stand to controvert the reasonableness of the billing.
Additionally, Your Honor, in this motion, I have also an objection to defense trying to include Dr. Sklar's contrary affidavit as a business record. And I don't think his contrary affidavit meets the requirement of the business record where they're trying to file under 90.
Let me ask this. Could you guys agree to dueling affidavits?
I wouldn't agree to it.
I think I would agree to dueling.
Okay. Let's just do dueling affidavits. I think under NRA Allstate, that's probably the safest thing to do for both sides. So, Tony, did we go on the record? I don't recall.
Yes, Judge, you did.
Okay. You're just not there, so I can't see if you're writing or not. So just to make clear, the parties have agreed that, I'm sorry?
I'm sorry, Your Honor, I didn't agree to it.
Oh, you didn't? I thought you said you did.
No, I'm sorry. No, I apologize if you didn't hear me. I said I didn't agree to dueling affidavits.
Okay.
I'm glad you cleared that up because I thought.
Sorry, yeah. I thought you said you did. I couldn't continue.
I apologize.
Yeah. I'll strike the portion of the affidavit as when it comes to causation. For the remainder, it's not struck. If you could prepare an order to that effect, Mr. Montrose, and get it to me as soon as you can.
Yes, sir, I'll do that.
And make sure that at the beginning of the order, it says that this was heard on March 14, 2022, as opposed to on this date. Make sure you share it with Mr. Cohen.
Yes, sir, I'll do that.
Anything else today, guys?
No, Your Honor. Thank you very much.
I'd encourage you guys, Mr. Cohen, to think about doing dueling affidavits on these in the future. I think it's after In re Allstate, it
Okay.
is what it is. So, but your call, and Rhonda, Tony, Ayana, our next hearing is at 4, but I'm going to sign on a little bit early. Rhonda, if there's any way you could call the attorneys in that Miles case and ask them to, I'm sorry, the Miles and the Johnson case, to see if they could sign on a few minutes early, because I'm hoping to leave at 4:30 because I have another hearing or another Zoom call I have to go to.